So now that you started a business in the US, the next thing you want to consider is IP protection outside the US. And you should consider that pretty soon and pretty quickly because there are certain instances where you need to be wary or aware of the timeline that you have to worry about. And just so everyone knows, IP protection is territorial. What that means is you're going to need to file in each country or jurisdiction where you actually want IP protection. For a business that deals with products, oftentimes you're going to have something got to do with a foreign connection. For example, your products or components may be made in China, and sometimes your products are sold overseas, although sometimes they're done without your authorization. So foreign protection is important in that sense. I want to give you a little background of the information regarding IP foreign protection. U.S. is a member to 5 international treaties and agreements related to IP. There are the Patent Cooperation Treaty, what we call PCT, and is applicable for utility patent, the Paris Convention for utility and design patents and trademarks, the Hague Agreement for design patent, the Madrid Protocol for trademark, and the Berne Convention for copyright. All of these are administered by the World Intellectual Property Organization, which we call WIPO. Note that these treaties and agreements only facilitate securing and to some extent maintaining these foreign protection. But there's no such thing as an international patent or international trademark that affords protection for the entire world. When do we need to seek IP protection? For patent, typically is you want to file it before the statutory deadline. And most foreign countries have an absolute novelty requirement so that you should file it before any public disclosure. However, if a US case is already filed, then you can claim priority to the earlier US filing under the Paris Convention. If it is a utility patent, you have 12 months to claim priority to the US filing. And for design patent, you have 6 months to claim priority to the US filing. So for trademark, you file foreign protection at any time. There's no deadline. Similar to the design patent, there is a priority claim under the Paris Convention for a 6 months priority claim. Although there's no time limit on when to file for foreign country for trademark, it is very important to file sooner than later, especially in first-to-file countries. In first-to-file countries such as China, the first one who filed a trademark application has priority rights. In comparison to first-to-use countries such as the United States, the first one who actually used the mark has priority rights. Some of the first-to-file countries, which does include China, but other first-to-file countries include Japan, Europe, Mexico, South Korea, and many other European countries itself, and many South American countries. As for copyright, you can foreign file a copyright at any time, similar to a trademark. One thing to point out is that under the Berne Convention for copyright rights are automatic, which does not require any formalities such as registration. Copyright created in a country is afforded the minimum rights in other member countries under the Berne Convention, such as protection for at least 50 years after the author's death for most work. There are a couple of options in foreign filing a patent trademark. It's direct versus indirect. On the left side, I show that the direct filing is basically filing directly in each individual country where you want protection. And the indirect route is using the WIPO agreements and filing it through WIPO, and WIPO will then send it out to various different member countries. For utility patent, the PCT international patent application can be filed. The PCT covers 153 countries, those that are shown in blue on the right-hand side of the map. After filing the PCT application, within 30 months from the earliest priority date, you'll need to enter national phase in a select country to continue with the application process, which is then similar to what you do in a direct filing. Each designated country then examines the application and then decides under its own rule whether to grant a utility patent. The PCT only facilitates the process by carrying out the search and written opinion on patentability, which is then available to the designated countries. But the designated countries are not bound by the search and the written opinion, and will often independently conduct their own searches in deciding whether to grant or not grant a particular patent. For indirect filing of a design patent, you can file a Hague, what we call a Hague International Design Application. It covers 91 countries. Those countries that are shown in yellow highlight. The US only joined the Hague International Agreement only 5 years ago, versus the PCT, which the US has been a member of for over 40 years. The only difference is once you file a Hague design application, as long as it meets the white book formalities, an international registration certificate is issued. Each country then examines the application and decides whether to grant protection. The Hague International Design Registration is only effective in those designated countries that have agreed to grant protection. Compared to PCT filing, the select countries must be done upon filing of the Hague design application. In the PCT case, you have until 30 months after the priority date to selectively choose which country to pursue the utility patent application. As for indirect filing for foreign trademarks, you would file a Madrid Protocol International Trademark application, and it covers 121 countries as shown in blue on the map. Unlike the PCT and the Hague filing, a pre-existing US trademark application registration is necessary before proceeding with a Madrid application. The US application is called the base application. If the Madrid trademark application meets the white book formalities, an international trademark certificate of registration is issued. Each designated country then examines the application and decides whether to grant protection. The Madrid International Trademark Registration is then only effective in those designated countries that have agreed to grant protection. An important note is that the Madrid International Trademark Registration is dependent on the base application for a period of 5 years. That is, if the base application fails or becomes invalid, then the international registration along with all the extensions will also fail. China is a member of the PCT, the Paris Convention, the Madrid Protocol, and the Berne Convention. Missing here is a Hague Agreement for the design patent application. So when filing a design patent in China, while you can claim priority to the US application under the Paris Convention, it must be filed directly in China and not through any white book resources. IP protection that are available in China includes utility invention patent, a utility model patent, design patent, trademark, and copyrights. So compared to US, we don't have the utility model patent. China has it, and a few other foreign countries do have utility model patent. A China utility patent is similar to a US utility patent, which are substantially examined. On the other hand, a utility model in China does not get substantively examined, and the examiner does not do a full prior art search and only gets reviewed for formality purposes. So it's a lot easier to get and a lot quicker to secure. Where it takes 3 to 5 years to get a utility invention patent, it only takes 1 to 1.5 years to secure a China utility model patent. The terms of protection is also shorter. It is only 10 years for a utility model patent and 20 years for utility invention patent. So why do I want to point out the China utility model patent? It is the speed of protection that is most important here. Instead of waiting for 3 to 5 years, you can secure protection in less than 1.5 years. Note that you don't really have to choose one or the other. In fact, you can apply for both invention and utility model patents on the same invention. That way, you can secure prompt protection of your utility model patent upon issuance. However, if and when you can secure the utility invention patent down the road, then you must abandon the utility model patent. And if you end up not able to secure a utility model patent, at least you'll have that protection. So unlike in the US, a China design patent does not get substantively examined. So it's a lot quicker to secure, and they only review it for formality purposes. So long as it meets the formality, it will grant the design patent rights. Typically, it takes less than 1 year to secure in China. In the US, it can take any time from 1 to 2 years. The term of protection is only 10 years versus 15 years for a US design patent. There is also an annual fee required to maintain a Chinese design patent, whereas in the US, there is no maintenance fee required at all. So for China trademark, China is the first to file country. What it means is that an infringer or squatter can easily hijack a brand owner's trademark and register it and prevent a legitimate brand owner from securing trademark protection. This is very common in China. While there are recourses for brand owner to try to get the trademark back, it is often a costly uphill battle and it's not guaranteed that you'll win. It is certainly much cheaper to file early than to having to fight for the trademark later. Another difference is unlike the US, where actual use of the mark is required to secure a trademark registration, you can secure a China trademark registration without use at all. This, along with the first to file system, exacerbate the infringer or squatter problem that many have faced in China. However, a trademark not put into use can be subject to non-use cancellation, as long as it hasn't been used for 3 years. Any interested party can seek that non-use cancellation. Examiners, a China trademark application is also a little different from the US. While US considers similarity of goods, China strictly considers the classification system by subclass. And similar to the US, it takes about 1 to 2 years to secure a China trademark registration also. Similar to US, China has a registration system for copyright. It takes very short time, less than a year, and typically as little as 1 to 3 months, you can secure a copyright registration in China. Whereas in the US, it can take us about 6 to 9 months, sometimes shorter, sometimes longer. But it generally takes a little longer in the US to secure copyright registration. So for a trademark that includes a design element such as the logo or even a stylized English mark, it is worthwhile to even try to secure a copyright registration for the design of a logo. Registered copyright can be used against a trademark infringer for any goods and services and not subject to the subclass issue. So it is important to consider all different coverage in China. Copyright is certainly something that is worth investigating based on the cost and the coverage that it can protect you on your brands. I just want to remind everyone there's really no such thing as an international patent or international trademark. And you really need to get protection on a country-to-country basis. Even the various international treaties and agreements that are available do not cover all the countries in the world. And it's somewhat impossible to cover even all those countries within the provided by international treaties and international agreements, because it's very costly to pursue every single one of those countries that are members. And second, to file sooner than later. It is very important. You snooze, you lose. And that's especially the case in China, and especially the case for patent where you have statutory deadlines. And for trademark, first to file country like China and any other first to file countries. Finally, I want to just point out that we do have contacts with IP professionals throughout the world that will assist us in any foreign filing rights. And this is a network of foreign professionals we've handled and dealt with in the past. If you have any questions, feel free to email me, reach out, and we'll be happy to assist you.